morning. Judge microphone 1, testing. Judge microphone 1. Judge microphone 2. Judge microphone 3. Judge microphone 4. Judge microphone 5. Judge microphone 6. And Judge microphone 7. Appellant mic. Appellant mic test. Test. Oh, goodness. And appellee mic. Appellee mic test. Sounds fun. Yeah. Well, if you did it before you. Let's give it a shot now. Pelly mic, test 2. Pelly mic, test 2. Very faint background. It's listenable.
Well, is it the crackling or is it just regular background noise? Oh, there is.
Wow. Just one. Hold on. Let's try this again. No? Okay. I think we're good. Wow. Regular background noise, I think.
The first matter before the court this morning is Oxford 25310, State of Maine versus James Peters. I see counsel are present. I'm assuming you're ready to proceed. We're being streamed on the web, both by audio and video. And so before we begin the argument, I would ask counsel to please introduce yourselves by saying your names for the record, together with the party you represent.
Jim Hawanick for the appellant James Peters.
And Charles Boyle for the state of Maine.
Thank you. And Attorney Hawanick, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Thank you, Chief Justice Stanfill, members of the Maine Supreme Court. I'm happy to be here on behalf of James Peters. Jimmy Peters met Joyce Brackett back around 2015, and they were in a relationship together for about 6 years. And he was in his 60s, and she was in her 70s. And I think she was about 77 when they first met. And for the next 6 years, they lived a quiet life in the Rumford, Mexico area. They had very little income. I was trying to check it this morning. I think she was making about $900 in Social Security income, and he was at about $600 as a retired fisherman, so about $1,500 or give or take. And they had no bills. They had a small house, and they were living happily. Joyce's children had no contact with her, zero contact with her face-to-face. There were some communications between the daughter and Joyce. Their dad had died almost 10 years earlier. During that time, there was no evidence of any problems. No domestic violence, no yelling and screaming, no police reports. Everything was quiet. Used to go to Old Orchard Beach and eat pier fries. That was about the most exciting thing that happened in their lives. Like is going to happen to all of us, Joyce, at the age of 83, her body began to deteriorate. She was diagnosed with cardiovascular disease. By the time of her death, she had a 90 or 95% blockage in her major artery, and she had other ailments that were developing. And towards the end of 2021, she really went into decline. They were cohabiting. He was her boyfriend. He was not her legal guardian. They weren't married. He undertook no duty of care to care for her. She declined pretty rapidly in that last week or two, developed this horrible abscess, ulcer on her chin/neck, and Jimmy got overwhelmed. He did the best he could to try to care for her, washing her genitals, caring for her. He honored her wishes not to take her to the hospital. She did not want to go to the hospital. She did not want to die in a nursing home. She wanted to die at home. And at the end, when that abscess got so severe that you could actually look through it from the outside into inside her mouth, he overrode her wishes, and he called the EMTs, and they brought her to the hospital.
Mr. Hawanick, I see that the green light is on. Thank you for the closing argument. Do you want to address any of the legal issues in the case?
The main issue from our perspective is that there's no evidence of an assumption of a duty of care. And
well, duty of care or in danger is it's not really duty of care. You're talking about the definition of in danger?
Well, I'm talking about an obligation to care for her.
Well, in danger is defined as a failure to act when the defendant has a legal duty to protect the health, safety, or mental welfare. That's what you're referring to?
Are you talking about something that's in the evidence in this case?
I'm talking about the statute.
Okay, fair enough.
Okay. And it says, however, for purposes of this paragraph, legal duty can be inferred if the defendant has assumed responsibility in whole or in part for the care of the dependent person. Now, you're not arguing that she wasn't a dependent person at that point in time, are you?
What evidence outside of his statements are you relying on? Because there's nothing in...
I'm not relying on anything. I just asked you a question. Is she? Are you contending that she's not a dependent person?
We would argue that the duty to care issue loops into the corpus delicti issue.
I understand. Can you clarify, would you mind answering? Are you contesting whether she is a dependent person?
I
as
am
defined by the
contesting
statute?
that. She was a very active individual until the last 2 weeks or so.
All right. So
She had her own finances. She
was
was a
there
very
at least a jury question as to whether she was a dependent person as defined by the statute?
Jury question still has to be based rationally on evidence in the case, and we don't think that's generated.
You don't think there was evidence generated that she had a significant limitation in mobility, vision, hearing? or
When did that develop? I'm asking rhetorically. I'm not asking you to answer my question.
I'm just trying to find out.
When did it develop? Was it at 3:30 in the afternoon on November 24th? Was it at when did that develop? Was it 3 days before she died? Was it 3 weeks before? 3 months before? Because I dispute that, Your Honor, respectfully. I don't agree with that. I mean,
Okay.
you can disagree with me, but I don't agree with that. I don't think there's any
It didn't seem like
evidence.
you raised that issue on appeal. That's why I'm trying to clarify the issues.
He was her boyfriend, and they lived together. And then she got sick, and he did his best to try to care for her. He washed her genitals. He helped clean her up.
Mr. Hwanek, I understand that that's your version, and that's the argument that you would make to the jury.
I'm not giving their version, Your Honor. I'm giving my version, okay? That's right.
Factually, I understand, but some of the facts were disputed, and I'm trying to hone in on the legal arguments that you're presenting to this court.
Your Honor,
And that had to do with, I understood, the definition of endanger, and whether or not he had a duty to protect her health, safety, or mental welfare.
I don't know how else I can answer it other than to say he didn't. I mean,
As you know, under the statute, a legal duty may be inferred if the defendant has assumed responsibility in whole or in part for the care of the dependent person. And we have your client saying, yeah, I'm her caregiver, I'm her caretaker, I'm the person who's taking care.
But he didn't say that. He told the police, I'm just her boyfriend. I tried to help her out. I tried to wash her in those last 3 days when she was bedridden.
I don't have it in front of me, but I thought at some point he said to the first responders, whoever got there, yeah, I'm her caretaker. I'm the person taking care of her.
I would have to check the record on that, but
Okay, I'm just working from
because
memory.
my recollection of his interviews with Herb Layton from the Maine State Police was that he was saying, look, I did the best to help her out, but I'm not her caretaker. She was very mobile. She wasn't suffering from
But
dementia
we know
or
from
anything
the
like
facts
that.
that they were cloistered. I mean, it's him and her in the house. The kids can't get in. The children can't get
Whoa,
access.
whoa, whoa, Your Honor.
Well, don't
I'm
tell me
sorry.
whoa, but,
I will strenuously disagree with that. In 10 years, the children drove by once the house, okay? And this was way before when Mom was lucid and very stubborn. She didn't want to see the kids. That's why the kids couldn't get in.
Okay,
In
but
10
they were
years, they
cloistered.
made no efforts
Do you disagree that they were cloistered? It's the two of them in the house that really has no outside contact.
What's the evidence? So what? Mom didn't want to see her
Well,
daughter.
I have a kind of a generic question. It sounds like you're focused in your opening argument and everything that has come on the facts, right? This is very important, the facts. So why is it in your statement of facts there isn't a single record site? What are we supposed to do with that?
Well, I think we've got we have law students
Our
who can
clerks
actually
are
read
supposed to
the
look up
transcript
the
on
record
appeal.
sites in contravention to the rule?
Your Honor,
The rule
I don't know.
requires you to do
I'm only, putting in about 80 hours a week on cases. We're doing the best we can, Your Honor, writing these briefs, okay? And so I think this is not a complicated set of facts. I don't think that the state even disputes a lot of what we say here, okay? This is a couple that were friends. They lived together for 6 years. She got sick at the
Again,
end
you're
of her
citing
life.
lots of facts. How are we supposed to know whether that's true? We have to rely on our clerks?
Yeah.
I've read the transcripts. Dr. Dodson testified that he talked to the defendant to try to find out what her status was. This is one of the ER docs in the Rumford Hospital. And the defendant told the doctor that she had not spoken in at least 3 weeks, hadn't gotten out of bed in 1.5 months, since she had fallen and that hadn't been able to get out of bed. How is that not a dependent person? Regardless, that's a different issue from the legal duty, and I understand your argument there. But how is that not a dependent person? If she can't
Assume that
speak
she
or
is a
get out of
dependent
bed?
person. Where's the intent to commit harm to this woman? Where's the intent? I'll grant you, for sake of this argument, Your Honor, that he had a legal duty.
You know that
How did
the
he intend to
endangering-
harm this
Okay.
woman?
And endangering is intentionally or knowingly endangering the health.
Right. Where's the intent? Where's the intentional and knowing behavior? He's supposed to know that she has sepsis. He's supposed to know
Well,
that she's
counsel,
suffering a
isn't that
95%
something-
blockage.
I mean, that's a jury question
It's a
ultimately,
jury
right? And
question.
isn't that something the jury can infer from the evidence in this case? He doesn't have to say, I intended to harm her, but he never sought medical attention, despite the fact that there's lots of evidence that she sorely needed it for quite a long period of time. Why don't we defer to the jury?
How beyond his own statements did any fact finder know that she slowly needed it? And that gets to my
That would be, I
corpus.
think you argued against the admission of the pictures, but the pictures show, the testimony of the medical providers and the pictures show and confirm that we have a woman who is completely debilitated and obviously to a layperson,
Your Honor,
unable to
I'm
care
glad
for
you brought up the pictures, because the one in particular, of course, is the one with her abscess on her neck. Even the state's own medical examiner said this was an infection that developed rapidly, and probably at the most 10 or 12 days out. It slowly developed to the point that we see in the picture, which is what it looked like on the day he brought her to the hospital. It didn't look like that the day before, 2-3 days before.
Mr. Hawanek, this is why we have trials, because there may be disputes as to some of the facts. We understand that. The jury found, obviously, to the contrary, and there certainly was evidence from which a jury could find to the contrary. Do you want to address your corpus issue in the minute you have left?
Sure. Well, first of all, back to the 403 issue. This is why we have trials, but we also have Rule 403, that ever so inconvenient rule that says, you can't bring in extreme evidence to try to inflame the passions of the jury. There's absolutely nothing probative on that. And perhaps in my rebuttal, I can talk about the corpus, because I think it requires more than 20 seconds.
So you don't think there's anything probative in the pictures?
I don't think there's any I'm sorry, Your Honor?
You don't think there's anything probative in the pictures? They don't offer evidence that goes to what the state needs?
Of what she looked like on the day he brought her to the hospital? No,
Sure.
I don't think, because it didn't look like that 2 or 3 days before. On the day he made the decision to overrule her wishes and take her to the hospital, you're right, that's what it looked like. He did the right thing on that day. But no, you saw that picture of her condition in the most extreme state.
Actually, she'd been cleaned up.
I'm sorry?
She had actually been cleaned up in the pictures. Attorney Boyle.
Madam Chief Justice, Associate Justices, may it please the court. When paramedics entered Joyce Brackett's home on the evening of February 10th, 2021, the sight they found was shocking. 83-year-old Joyce was incoherent, bedridden, covered in her own filth, with a hole in her jaw through which the EMTs could see the inside of her mouth. And more than 4 years later, each of the emergency personnel, nurses, doctors who testified at trial had a vivid and independent recollection of their efforts to save Joyce that night. This is one that stuck with each of them. The trial court here did not err in denying Peter's motion to dismiss as to the corpus delicti argument. He's argued that the state has presented no evidence, save for his own statements, that could create a substantial belief that any crime had occurred and that the trial court erred by finding to the contrary. That's just not accurate. Even ignoring Peter's numerous admissions, the record evidence is more than sufficient to satisfy the very low burden required by the corpus delicti doctrine. In denying the motion, the trial court correctly laid out the appropriate legal standard. It cited specific record evidence to support its conclusion that the state had carried its burden, and the factual findings underpinning that conclusion were not clearly erroneous. Nor did the trial court err in failing to sua sponte enter a judgment of acquittal. Peters has argued that the evidence was insufficient to show either that he acted intentionally or knowingly, or that he owed any duty of care to Joyce. That, again, is just not borne out by the record evidence. Viewed in the light most favorable to the state, the trial record contains a host of evidence from which a rational jury could have concluded that Peters owed Joyce a duty of care, and that he knew his repeated failure to act was likely to endanger her health or her welfare. And finally, the trial court did not abuse its substantial discretion in admitting into evidence a limited subset of photos of Joyce's injuries. Contrary to Peters' assertions, the trial court did take prophylactic steps to limit the possibility that these exhibits would elicit an unfair emotional response from the jury. The photos admitted into evidence were accurate, they were relevant, and they were highly probative of Peters' guilt. In his brief, Peters calls the condition in which the paramedics found Joyce that night part of the natural indignities of aging, rather than any evidence of a crime. I would respectfully encourage this court to carefully examine the photos of Joyce that are part of the trial record, the ones that were sufficiently sanitized for admission, in determining whether her state that night was natural indignity or evidence of something more nefarious. The jury here came to a unanimous conclusion on that issue and did not do so in error. I would welcome your questions. Thank you.
Based on the brief that was filed in this case, I believe the defendant is raising, in addition to the photos, two other issues. First, that there was no duty of care, and second, a lack of corpus delicti. In other words, that without considering his statements, that there needs to be credible evidence to create a substantial belief that a crime was committed by someone, correct?
Correct, Your Honor.
Don't you then have to, without using his statements, establish that someone had, in fact, assumed responsibility in whole or in part for her care?
Correct, Your Honor. Based on the state's theory of the case, that would be necessary to prove.
Okay, so what is the evidence that someone had assumed responsibility for her care without using, and you said even if we don't, even ignoring his admissions, but for the corpus delicti rule, you must ignore his admissions. So what is the evidence?
So, Your Honor, setting aside his admissions and setting aside mens rea and identity, although identity necessarily comes in when you start getting into these facts.
Well, the question is without his admissions.
Right. What record evidence is there that somebody had at least partially assumed care for
Could be that
Joyce?
he had, but it needs to be.
So we have testimony from two of Joyce's adult children that at the time that she left their home in South Portland, she did not drive.
Well, that was Philip's testimony, his
Right.
son, who hadn't seen her since 2016.
Correct. Julie, the daughter, who had communicated electronically on the phone and emails with her mother in the intervening period, did not testify to the contrary about mobility, ability to leave the home, who did the shopping. And then you go to the physical evidence, starting with when the paramedics arrived at the house, what did they see? Corroborated by photos taken by Major Crimes the next day when they executed a search warrant. We have some evidence of somebody who's being cared for, not particularly well, but being cared for at least for some period. Absorbent pads on furniture suggesting incontinence. Mobility aids in the shower, including handholds and a walker. Wipes next to where Joyce was found. Dirty wipes near where Joyce was found. Nitrile gloves found in that room. And then you can infer from the state of Joyce when she was found that somebody had cared for her, at least partially, or else she likely would have died far sooner than she did. The testimony from the treating providers and from the deputy medical examiner was that a number of these injuries and illnesses must have progressed over, if not days, like weeks. And in order for her to have survived for that period without being ambulatory or able to participate in any activities of daily living, feed or water herself, someone must have helped her. And the state's evidence was that if anyone cared for her at all, it had to have been James Peters.
And so it's your position that there was sufficient credible evidence without using his statements?
Yes, Your Honor.
At the time of the corpus delicti hearing, was there any testimony regarding the house itself, people coming and going, whether or not there was anyone else in the house or having access to the house?
No, Your
part of the
Honor.
corpus delicti?
So at the time that the court considered the corpus delicti issue, the state had finished its case in chief.
There was no separate hearing? There was
No,
no
Your
motion
Honor.
in limine or anything like that?
It was taken up at the time that one might normally take a Rule 29 motion. No, as Your Honor appropriately pointed out, these people had been cloistered for perhaps as long as 6 years. There was no record evidence that anybody had seen Joyce Brackett face-to-face in at least the last 18 months of her life. There was no physical evidence suggesting anybody else coming into the home, no evidence suggesting home care, Meals on Wheels, anything of that sort.
If two people are living together, cloistered, but with no legal relation, no marriage, no legal orders, anything else, they're just living together, I assume you would agree that that by itself doesn't create a duty of care.
Not according to this statute.
There has
no.
to be something more.
Correct, Your Honor.
And what is the something more here from which we could infer that he in fact undertook or assumed responsibility for the care of the dependent person?
Well, if we're just looking to sufficiency of the evidence, and now we're considering his admissions, they were numerous. Mr. Peters spoke to detectives a number of times, including 2 substantive interviews that were admitted in full at trial, more than 4 hours of audio. I disagree with what was just represented by appellant's counsel as to whether or not he admitted directly that he was the sole caregiver. According to my listening to of the audio and the transcripts, James Peters told detectives Reed and Shabbat in that first interview just after Joyce was rescued, they said, "Are you her sole caregiver?" And he said, "Yeah." Later in that interview, they discussed what that looked like. Detective Shabbat suggested that caring for Joyce, including shopping for her and picking up her prescriptions, must have been a burden on him. Peters acknowledged that he did those things, but said it was no burden, no trouble, because he loved her. He went on to describe in detail some of the activities he took to try to clean or care for her, including carrying her around the house, and at least at the beginning, cleaning the feces and urine off her body. All of that is sufficient for a jury to find that he had at least partially assumed her care and that duty had attached. If the court has no further questions.
What's the proper way of raising a corpus delicti argument? Obviously, Justice Meade asked a question, and there, in this case, there was no pretrial hearing on it. Should there be? Is it appropriate to raise it only at the close of the state's case? Is it an objection to evidence coming in? What's the proper way to raise a corpus delicti argument?
I think it would be perfectly appropriate to raise it pre-trial and ask the state to put on some sort of showing, because as this court has noted, this is something like probable cause, this standard. It's low, and we need not proceed through an entire, what ended up looking like a manslaughter trial in substance in order to reach that question.
But it could be raised, I mean, from a defense point of view, you may not want to tip your hand that you're thinking there
I'm not
may be
aware of
something
any
missing.
rule that requires that it be brought up at any point, pre or during trial.
Okay.
What do you think we should do with a brief that doesn't have any record cites in the statement of facts? Should we reject it? Should we ignore it? What should we do?
The state took great care to cite specific facts in its brief, and I would
Correct.
encourage this court to focus on that set of facts.
Very diplomatic answer.
Thank you, Your Honors.
Thank you. And Mr. Hawanik, you did reserve 3 minutes for rebuttal.
Your Honor, veteran Maine State Police Detective Herb Layton was the lead detective in this case. And he's been around for like whatever, since ancient history. And is the classic example of why we have the corpus delicti rule. And I encourage the listening of the 4 hours or so of interviews, because it's nothing but an effort to get our client into gotcha moments, just like he did in a case that was, I think, argued before you a couple months ago in my shaken baby case, where he's berating a defendant who's just been under suspicion for shaking a baby to death and trying to get a gotcha moment. He tried to do it in another murder case I did. We got an acquittal in that case because the state didn't believe him. This is why we have the corpus delicti rule, is so that people don't get convicted just on their statements. And I heard a lot of reliance on the defendant's statements in that last argument. You have no evidence, certainly nothing from the children, nothing from any local police or DHS workers or Meals on Wheels workers or anything, that there was any problem for 6 years in this household. The word cloistered because Joyce didn't want to have anything to do with her children. That's why she's cloistered. She was a very independent woman. So, you know, we got to be careful about throwing these things around, because the image is that, well, we got this younger man, late 60s, taking advantage of an older woman. That was not the case at all. And absent the gotcha comments that Herb Layton tried to get from my client, which we think he actually acquitted himself well in, there's absolutely zero evidence of an assumption of duty of care. A couple of tissues on the floor? Give me a break. How long were they there? When did he assume the duty of care? 3 days before?
Well, let me ask you that. Is there a time frame? In other words, I don't see one in the statute. Do you think that it says simply if he assumed responsibility in whole or in part for the care of the dependent person? So do you think there needs to be a minimum time frame?
My 90-year-old father, we tried to keep him out of the nursing home. He gets a pancreatitis attack. I don't know what pancreatitis is. I says, Dad, let's see if we can get through the night. You know, I don't want, if you go to the hospital, you're never going to come home. He suffered those last 20. I should have taken him to the hospital 24 hours earlier.
Would you agree?
Am I a felon?
Would you agree hypothetically, this is a hypothetical case, but if people living together, just the two of them, and one is literally watching the other rot away, but doesn't call any assistance in the meantime, this incontinent, just losing it over a period of time, not making it this case, but would you agree that that would trigger a duty for a person?
There's a lot. I mean, there's a lot. You're throwing a lot of hypotheticals in there, but Your Honor. But I mean, does she want to be brought to the hospital? Is she able to communicate? I mean, there's a lot of questions that we need to answer here.
Thank you. Thank you, counsel. As is our usual practice, we will be taking the matter under advisement, and we will issue a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
Good morning. You can be seated. The matter before the court is Somerset 25305, State of Maine versus Devin Stewart. I see Councilor Preddy are present, I'm assuming ready to go. We are being streamed on the web, both by audio and by video. And I would ask, before we begin the argument, that counsel introduce yourselves by saying your names for the record.
Good morning, Your Honor. Kayla Alvis for the appellant, Devin Stewart.
Good morning, Your Honor. Tim Snyder on behalf of the State of Maine.
Thank you. And Attorney Alvis, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Thank you, Your Honor. Chief Justice Stanfill, members of the court, good morning, and may it please the court. Arguably, there is no greater crime that carries a stigma than sex crimes. Once a person is labeled a sex offender, they are largely shunned by the general public, regardless of what that crime entailed. The stigma begins when a person is charged, and it can last throughout their lifetime. As such, when having a trial, we must not introduce anything that could be unduly prejudicial to a defendant. In this case, regardless of how the 911 call was entered, whether it's through 803 or 804, the core issue is that the victim was allowed to leave the courtroom during the playing of the call. It shows the jury that the crime must have been so bad that the victim couldn't even be in the same room when she was listening to her own words. Again, stigma. A statement that the appellant cannot be around minors is not ambiguous, as the state argues. It is a bell that cannot be unrung. Who cannot have contact with minors? Sex offenders. The undue prejudice of introducing the prohibition of being around minors in the middle of a trial for a sex crime is nothing short of an atomic bomb. It is a statement that condemns without a conviction. These issues, while seemingly unrelated, are all connected and only amplify each other. At sentencing, the trial court lambasted the appellant over his lack of remorse during the second step of the Huey analysis. The trial court said a complete failure to take any responsibility, minimizing involvement, denying involvement, going to trial, and just bald-faced lying. This was all said during that second step. The appellant, asserting his constitutional right to take his case to trial, is not a failure to show remorse. He is simply exercising his right and forcing the state to do their job. I'm happy to take questions.
So I'd like to talk to you a little bit about preservation and standard of review. The issue on leaving the room during the 911 call. I mean, is your, I guess, first of all, I have a couple of questions about what you're really arguing, but I'm reading the transcript, and it feels to me like not only is there not an objection, but it is waived. In other words, that is the tape going to be objected to? Specifically, he says, I think that's what the judge is referring to, and I'm looking at Appendix 12. I have no objection to it, and they're talking about the fact that she wants to leave the room, and he says, it's just with the understanding that I reserve the ability to cross-examine her about it. They talk about it again, and then he says, the court says, do you want to cross her on something the jury hasn't heard yet? Do you want to wait, have it played? Defense counsel said, yep, that's the way I want to go about it. Have her step out of the room, and you can play it, and then I can cross-examine. I mean, isn't that not just not an objection, but waiver?
Your Honor, I think that I hear what the court's saying. I think that that's an error, quite frankly, and I was not the defense counsel.
It may have been an error by defense counsel, you mean?
Potentially, yes, Your Honor.
Okay, but regardless, isn't that a waiver of any issue as to having the 911 call played at all, with or without her in the room?
I don't think that it's a waiver in regards to the stigma that comes with it. I understand as far as the rule of evidence and why an attorney may want to waive that and why it may seem like it's a waiver.
Well, there wasn't even an effort to get any type of corrective instruction after all that had happened, because I think there were at least 3 or 4 occasions in which this whole issue came up and was being addressed by the court with the counsel for the defendant.
Yes, Your Honor. I think that that is a defense counsel problem.
Well, let me ask you another question. So on the issue about the statements that he's not supposed to be around minors, I'm also going on preservation on that. So what happened was the person was testifying, the victim was testifying, said he noticed, and again, I'm at Appendix 19, he noticed a normal police car, and he's like, oh, damn, because he had told me after the police came, like, not for us, but the police coincidentally, and then it says objection. And the court says grounds, and defense counsel says prejudicial statement that in effect, and then the court jumps in and says, well, you're quoting the defendant, is that what you're about to do? The witness says yes, and the court says overruled, because it appeared like it was somehow a hearsay objection. Although he said the words objection, there is no way that the court is going to know from that exchange what he's objecting to or why he's objecting, because there's nothing, as I read it, the court has no idea what the victim's going to say. The defendant didn't identify what he was afraid that the victim was going to say, that the defendant had told her that was prejudicial. And it doesn't, again, does that mean it's not preserved at all? And I'm looking at, for example, Rule 51, which says, you know, an objection, you have to make known the action the party desires the court to take, or the party's objection to the action, and the grounds therefore. And our case law saying even saying the words objection is not enough unless the court is fairly apprised of what the issue is. And I don't see how the court would have known what the issue was that was coming here.
I understand, Your Honor. I think that even an imperfect objection is enough to create the record and to object.
So we should overrule our cases that say purely general objections fails to comply with the rule, and that's not sufficient?
If that was the rule, no attorney would ever give a reason. They'd simply say objection, and then later on look for the rules of evidence and decide what they want to hang their hat on. We can't have that as a rule, can we?
No, absolutely not. That would make trials very easy.
But here there was, I'm looking at Appendix 19, he says objection, the court says grounds, and the defense attorney says prejudicial statement that in effect, and then the court cuts the attorney off and says to the witness, you're trying to say something about what the defendant said. So I think, I mean, tell me, but might you argue from that he tried to explain what the prejudice was and wasn't able to finish, the court cut him off?
Absolutely, Your Honor. I think he very quickly recognized that it was going to be a prejudicial statement. He wasn't given the opportunity to finish his argument.
But isn't it defense counsel's obligation at that point to say, you know, sidebar, basically? You know, as somebody who taught trial practice, my teaching was you have to proffer, you know, if permitted to answer, this is what I expect the witness is going to say, and that's why, because the judge doesn't know that.
At the same time, though, Your Honor, the judge also didn't give the defense attorney an opportunity to finish his argument. And so, as somebody who does regularly do the trials and stand in front of justices, when a judge says, I've made my order, sometimes it's very easy to say, okay, it's done.
But isn't that the responsibility of defense counsel? Ask for sidebar at that point, because obviously if you're going to say what you expect the witness to say, you can't do that in front of a jury.
He certainly could have, yes, Your Honor.
And say I need to preserve my objection and make my record, make it clear why I was objecting.
I think that he probably could have done it better. He certainly could have asked for a sidebar, but he also highlighted that there was going to be a prejudicial statement. He recognized it, and he did make the objection, even if it is imperfect.
Could you address the state's harmless error argument that even if it was error to have admitted the statement, it was an ambiguous statement, at least the witness wasn't asked to explain what she understood the defendant to mean or anything like that, and it was never referred to again in the trial. So why isn't it harmless given the nature of the evidence in this case?
I think that it's not harmless because it's the middle of a sex trial. There is an allegation that there's a statement that he cannot be around minors. It goes back to the stigma piece. And it leaves a jury with an absence of information. What does that mean? Is he already a sex offender? Has he already been convicted of something? What has he done wrong? It's the same argument for why when we have trials and a client has two charges, one is a felony charge and another is a misdemeanor VCR charge, we don't introduce the VCR charge because we want people to be judged on the conduct, not on, well, he's on bail, he broke bail, he must be a bad person. So having that statement, even though there isn't a lot of exploration or really any exploration of that statement, I do believe is absolutely prejudicial in the middle of a sex trial.
The statement itself, though, could mean a lot of different things. Would you agree with that?
No, I don't agree with that, Your Honor.
You think that it only can be interpreted as he's committed a sex offense against a minor in the past?
Off the top of my head, I can't think of why somebody would not be allowed to be around children. It's not just one person, it's not just a child, it's children, period, from infancy until they're 18.
Was there any request for a limiting instruction or curative?
There was not.
It's my understanding there wasn't an offer of proof ahead of time, so the judge didn't know what was coming. Is that fair?
Yes, that's correct.
If there had been a request by defense counsel to have the state make an offer of proof at that point, that would have been a prudent way to approach the circumstances as opposed to simply saying prejudice. It may well be, I'll let you answer the question in just a moment, but it may well be that the judge is sitting there and the judge doesn't want anybody to blurt out what the statement is. And if it sounds like, well, prejudice, I'm talking about a 403 balancing, just say on the basis of it, obviously, if it's his statement, be a statement against interest, statement of a party, so it would come in, so the judge is hanging their hat on that particular point. But at that point, in addition to clarifying what the objection is, would it have been prudent for the defense counsel to request that the state make an offer of proof as to what the statement is going to be?
I believe so. I think that a lot of things certainly could have been differently, yes, Your Honor. I think that defense counsel could have said, we need to go to a sidebar. I think that it would have been helpful for the trial court to let the full argument come out. I understand that everybody's trying to balance things in real time and nobody wants anything to come in that shouldn't.
Was defense counsel aware of what the state, did it come out in discovery or something? Did defense counsel know what was coming?
Yes.
Okay.
That is my understanding, yes.
Okay. All right, so they knew that this was, in your opinion, bombshell stuff, but let it go simply without requesting further clarification.
Yes.
Okay.
But it's also relevant, right? Because it was an explanation by the victim as to why he was walking ahead of her, right?
I don't know that, yes, I guess that it is relevant, but I don't think that the relevance outweighs the prejudice here.
Well, is there that much prejudice, though, to the extent, I know you differ with Justice Lopez's observation that it may not have been, even in the context that it was given, it may not have been that important to the jury. But just to go further, perhaps defense counsel, once the statement's out, decided that it was so brief and minor with respect to the balance of the evidence that was coming in that he didn't want to highlight it after that.
That's not my reading of the transcript, Your Honor. I mean, he objected quickly because he knew what was coming. So it didn't sound like he was fine with something like that coming in because it was so minor.
But once it came in, he may not have wanted to highlight it by requesting an instruction or even moving to strike the statement, since the judge clearly did not understand what it was that was going to come in.
Yes, I apologize. I did misunderstand that. Yes, he did not try to do anything after that. He didn't try to remedy that.
Can I go back to the 911? Can I clarify again? What is it that you're arguing? That she shouldn't have been, that the tape recording shouldn't have come in at all? That she shouldn't have been allowed to leave the room? I wasn't really completely clear.
It was that she shouldn't have been allowed to leave the room, Your Honor, not that the tape should have not come in.
So are you asking that there be an ironclad rule, a bright line test here that says no victim shall ever leave the courtroom?
I think that when it comes to a victim or a complainant, I do think that they need to be in the courtroom, Your Honor, especially if...
In courtroom for what? We don't allow them to be in the courtroom for everything.
Certainly, thank you. If when their statements are being played, certainly, and they are being questioned about it, I do think that that's important.
And what is it important to? With the jury watching the demeanor of the declarant?
Certainly, I think it is part of that. Additionally, because she didn't want to hear the recording at all, she couldn't have even been cross-examined with that to actually have her listen to portions of it. And so defense counsel was essentially stuck with whatever her answer was.
But how would the jury know that she didn't even want to listen to the recording at all? I mean, she just exits the courtroom. The jury, I'm trying to get the sense of why that has an impact on the jury if they don't know why she's leaving.
I don't think that the jury would have known why she was leaving. I think that the trial court did a good job at separating that.
And then there was an opportunity for cross-examination once the 911 had been played.
There was an opportunity for cross-examination. The issue is that there were issues with her responses regarding the 911 call, and she could not have been challenged on it because she didn't want to hear the recording.
But it didn't have to be admitted even during her own testimony. I mean, they could have not asked, you simply asked her, did you make a 911 call? Yes, and then put it in entirely through a different witness. I mean, there was no requirement that it come in through her.
May I could answer?
Yes.
So I agree. I think that was the initial plan, that they were going to bring it in through the detective. And again, I wasn't trial counsel, so I don't know all of the nuances about why that didn't happen. But that is correct, that it could have come in from
It
someone
seemed like
else.
defense counsel wanted it to come in through her so he could cross-examine her about it.
Yes.
Thank you.
Thank you.
Attorney Snyder?
Chief Justice Stanfill, Associate Justices, thank you for the opportunity to speak on these issues today. This gross sexual assault case established sufficient evidence to support a finding that the appellant forced the victim into a sexual act as a result of compulsion. The direct evidence included that the victim was kissed without consent, that she was groped, pushed against a railing, and anally and vaginally assaulted, and that she screamed no and stop as the assault took place. The circumstantial evidence included that she described she was in pain to first responders, that her demeanor immediately after the assault, that she called 911, and that she was transported to the hospital for a sexual assault examination. This examination ultimately found the appellant's DNA inside the victim's vagina, despite the appellant's repeated denial that any sexual contact had taken place. As to the second issue, there was no obvious error in the trial court's decision to allow the 911 call to be played while the declarant was out of the courtroom. The 911 call was admitted as an excited utterance. That exception allows for hearsay to be admitted regardless of whether the declarant is available as a witness. 911 calls containing excited utterances are often permitted when the declarant never appears at trial. Here, the defendant did appear and was available for cross-examination. Next, the admittance of the victim's ambiguous testimony about the appellant's statement was not an error. The victim testified that the appellant, quote, told me after the police had went that he's not supposed to be around minors, end quote. At no other point in the trial did the prosecution or any other witness reference that testimony. The testimony itself could be interpreted in numerous ways. At the time the testimony was given, there was no defense objection because the testimony was ambiguous and not clearly objectionable. Finally, the sentencing court properly applied the Huey analysis and appropriately weighed the aggravating and mitigating factors. The court gave credit to the appellant for his youth and lack of criminal history. The court found that the subjective effect on the victim and the appellant's lack of potential for rehabilitation to be aggravating, and the court also found the sex offender evaluation to be one of the most, quote, most chilling sex evaluation risk assessments that he'd ever seen. With those issues in mind, Your Honors, I'm happy to take your questions.
The sentencing, though, didn't the judge said that essentially you failed to take responsibility was an aggravating factor? How is that not, I guess, the follow-up is, how is that not punishing somebody for their trial?
Yes, Your Honor, thank you. After he was convicted, he did a sex offender evaluation. His sentencing was delayed by about 5 or 6 months. During that evaluation, he repeatedly denied that he sexually assaulted the victim. He repeatedly shifted the blame onto her, claimed that the district attorney's office it was a setup and that her testimony was staged. So I believe when defense highlights that it's taken out of context and that the judge is actually referencing the sex offender evaluation and
But counsel, what is the defendant supposed to do in those evaluations? I mean, just because he's been convicted doesn't mean he's given up his, privilege against self-incrimination. We've got an appeal going here. I mean, so I'm concerned that a court could find denials in one of those evaluations to be an aggravating factor. He still has his right to maintain his innocence, doesn't he?
That's understandable, Your Honor. I think that in this case, calling the victim a liar and that the whole thing was staged is...
Did he have the ability not to do the sex evaluation at all, to just rest on, I've got an appeal going, I don't want to say anything at this point?
I think he could do that. He decided not to.
If I could ask you more about the sentencing, because I do have some concerns here. There are 3 different places where the court references the defendant's, remorse or acceptance of responsibility. So first and I'm looking at page 28 of the sentencing transcript, when talking about mitigating factors, the court considers whether the defendant was sufficiently remorseful. That may be fine. And then on the next page, page 29, the court says, now I'm going to talk about aggravating factors, and says, I take into account in my mind the almost complete failure on the part of you to take any responsibility for this until way after the fact. How can the failure to take responsibility be a proper aggravating factor under our precedent?
In other words, taking responsibility may be mitigating, but how is a failure to take responsibility aggravating?
Well, I think maybe a failure to take responsibility might be an issue, but when you start making proactive statements that you're calling the victim a liar is slightly different.
Well, and let me ask you about that, because we certainly have said if the court finds that a defendant takes a stand and lies at trial, that might be an appropriate aggravating factor. And then the court does, a page later, page 30 of the transcript, say it's not okay for someone to go to trial and just bald-faced lie, and so I'm aggravating for that. But there's this statement before that that's untethered from discussion of the trial testimony. As I said, it's sort of a page earlier where he just says, I'm going to aggravate for failure to take responsibility. You're suggesting we should not read that as a separate aggravating factor, that really that was just the court referencing the trial testimony?
Well, I do think that in this sentencing, even in reviewing the transcript, and I was there personally, that the judge, he kind of circles back to issues, and it's a little stream of conscious. And I do think that this was all within the same discussion of what he found to be aggravating.
We've been trying very hard to make it clear that absence of an expression of remorse or absence of an expression of responsibility, again, does not necessarily count as an aggravating factor. I mean, we've been issuing quite a few decisions along those lines.
Yes, and
isn't there a responsibility to ensure, because people do have a right to have a trial and the right to remain silent, the right not to allocute, the right to maintain their innocence all the way up to appeal?
I don't dispute any of that, and I agree, obviously, with the precedent. In this particular scenario, the appellant did make statements that were not just not taking responsibility or no comment. In this one, at times he lied. Well, at least that's what the jury found and what the judge cited.
What is the state's attorney to do? Let's say you're listening to the sentencing and the judge says, all right, step 2, aggravating circumstances. Well, he has refused to take responsibility for this, and you hear this. Is there anything you can do at that point?
I was thinking this in my mind, and I don't know, partially the cat might be out of the bag, but I think maybe the state's attorney could also ask to approach and highlight precedent and maybe have it at least at a minimum addressed at that time rather than it not be addressed.
I understand the difficulty of the position you're in, though, at that point. Can I ask you about the statement that Stewart made about not being around minors? The court didn't conduct the 403 balancing analysis because the court didn't know what the answer was going to be ahead of time. It's admissible under hearsay rules, but I'm wondering if perhaps after having heard that, the court might sua sponte have undertaken a 403 analysis, and I want to ask you about where you think that would head. As you know, the danger of unfair prejudice is part of the balancing act there. And the test for relevance is whether the evidence being proffered has a tendency to make a fact of consequence more or less probable than it would be without the evidence. So my question to you is, what fact of consequence is made more or less likely by the fact that he said he can't be around minors?
I don't think that it's very relevant, but at the same time, I also don't think that there's any.
What is it relevant to? Let me just stop you there. What fact that you want to get into evidence is made more likely by the fact of his statement coming in?
Well, if anything, it provides the context between the two individuals to help people understand what's going on in that moment.
Well,
but
how?
Well, I'm not going to defend that statement.
Well, it sounded like
because
you were earlier.
Well, it was a direct question, so I was attempting to give my best possible answer for it, but my answer to it would be slightly different, is that I don't think that there's any unfair prejudice. It's really just not relevant, but
You don't think there's unfair prejudice in saying, by the way, I'm not allowed to be around children in a sex case?
I'll just supplement that. As I parsed it out in my own head trying to be the trial judge, I say, okay, probative value, really, I really see virtually none. Unfair prejudicial effect, oh yes, this guy's prior convicted of a sex offense. So it seems to me the balancing test isn't even close. I realize you're not embracing this fact, you're not delighted that it's in there, but do you think the judge had a duty to sua sponte undertake a 403 test after the evidence came in?
The statement was so ambiguous for a couple of reasons. One, the meaning could not be determined. Even to this day, there's an assumption that that's what he's talking about, but even in the moments leading up to that statement, she's talking about how she skipped school and how she was out and had skipped school that day. The very next statement is in relation to this, I can't be around children. So that's an assumption that it's a reference to a prior sex case.
Well, but even if it weren't a sex case, it's certainly somebody who's not allowed to be around children, one assumes it's because they do something bad to children, whether it's sexual offenses or something else.
That's possible interpretation.
Well, you said there were lots of other reasons. What are the other reasons for not being allowed to be near children?
Well, if somebody's skipping school, for one, would be you shouldn't be around the kid and promoting that type of behavior. But also throughout the trial, he's referenced on his own accord, had brought up that he had been smoking marijuana that day and was...
But none of those things result in a prohibition on him being around children.
That's correct. And the statement was not flushed out beyond those words. So what the prohibition was, who made the prohibition, was it the court,
So you're really
was it his
arguing
mom?
harmless error.
Yes, harmless error.
Not that it's not error, but more that it really didn't have much of an impact.
I would primarily say that it's harmless error, but I just don't think that the record was flushed out enough in relation to that for it to even be an error, because it could have, he didn't even say that the court said there's a prohibition.
Wouldn't flushing it out or fleshing it out more have just simply compounded the error?
Yes, I would have never flushed it out, never recommended it to be flushed out, but I just don't think that, we just don't know who this prohibition came from, who's imposing it. We don't know anything about
And
it.
so the jury speculates, that's the problem.
That's what I'm getting at. I mean, here, it's not a hearsay statement, so the judge probably figured, oh, okay, statement. So the judge clearly was thinking hearsay. And then it came in, and we talked about whether or not defense counsel had a duty to light this up. And I asked you whether the judge had the duty sua sponte to light up. Neither one did that. So the first question is, was that error? And if so, was it harmless error? And I don't know where you're stopping. There's no error or harmless error, but can you clarify whether you're saying it was error for the judge not to step in, or you're saying the judge should have sua sponte stepped in, but it was harmless error not to?
My first argument is not error because the statement's unclear. My second argument is that it's harmless error because it's so ambiguous as coupled with the rest of the evidence in the case that it qualifies as
And no one
harmless.
highlighted it, no one relied upon it in argument, et cetera.
Yes.
Can I take you back to aggravating and mitigating factors? In fact, in this case, if I recall, didn't Justice Mullen give credit to the defendant for expressing remorse at the time of the sentencing hearing?
Yes, he did.
As distinguishing that from not taking responsibility.
Right. Yes. He did, as well as his youth and lack of criminal history.
There don't appear to be additional questions. You have 1 minute and 6 seconds.
I have nothing further to add. I appreciate your time today.
Okay, thank you.
Actually, Your Honor.
Oh, go ahead.
I forgot one thing. There was
Did he just-
another issue, I believe, that was expressed in this matter, and that was with respect to whether or not there was a problem with the sentencing in terms of the probation. And your position is that that was error?
Yes, I've reviewed it. I believe the statute authorized for 4-year period of probation. He
Is
was
that something
sentenced-
we can correct, or does that have to be corrected on remand?
I'm not certain, Your Honor.
But wouldn't we want to give the trial judge an opportunity to rethink that situation?
Yes. Yes.
Thank you. Oh, and you didn't reserve any time for rebuttal. So never mind. All right, then with that, we will take this matter under advisement and issue a written decision in due course. And I understand as well, Mr. Snyder, that this is your first appearance in front of this court. As is our custom, then, we would invite counsel to come back into the conference room and take the greetings of the court. So we'll see you back there. To this morning's prize argument in the case of United States versus Ronald Drum. Welcome to all the students who are here, all the families, loved ones, hangers-on, and various other people who may be in the room. I'm going to extend a particular welcome to the faculty members from the law school who are here. There's too many people for me to find all of you, but I understand that Professors Ari, Wolf, Neatery, Caruso, Chapman are all here. Welcome. Thank you for giving us this opportunity to work with your students. We always appreciate it. It's one of the highlights of oral arguments at this time of year. And I see that we have students who are in the well, I'm assuming, ready to proceed. So we will call the matter, which is number 2542, United States versus Ronald Drum. Before we begin, I would ask counsel to introduce themselves together with the party they represent, starting with the appellants.
Chief Justice Stanville, Your Honors. Zoe Sobel, joined by co-counsel Tanner Kelly, representing the appellant Ronald Drum.
Chief Justice Joseph Inabanza, alongside Bana Al-Humphney, representing the government of the United States.
Thank you. And counsel, if you're ready to proceed, Attorney Sobel would be happy to hear your argument this morning.
Chief Justice, may it please the court. Modern vehicles are inherently different from cars of the past. Rapidly advancing technology has transformed vehicles from a simple mode of transportation into cell phones on wheels, capable of storing highly personal data generated by the vehicle and connected digital devices. Your Honors, this court should reverse the decision of the United States District Court for the Northern District of Newver, Maine, and hold that a warrant is required to search a vehicle's digital data because the automobile exception does not extend to a vehicle's digital spaces. This court should reach this holding for the following two reasons. First, the automobile exception does not permit the warrantless search of a vehicle's digital data stored on the onboard computer and SVR systems. Second, even if the automobile exception applies to a vehicle's digital spaces, the search in this case was unreasonable because it did not meet the requirements of the exception. Turning to my first point, this case is like Riley, and this case should be decided.
Well, I see that the green light is on. And let me ask you this. Putting aside the digital search, was there probable cause to search the vehicle?
Your Honor, no, there was not probable cause to search the vehicle. When looking at probable cause, it exists when the totality of the circumstances lead law enforcement to believe that they'll find.
Well, we have a witness who said he saw the vehicle swerving immediately before the accident. We have an accident involving serious injuries where vehicle's gone off the road. Defendant apparently had at least some indicia of being under the influence, and a witness who said it appeared that he was speeding immediately before the accident. Is that not probable cause to believe that there may have been either, whether it was reckless driving or driving under the influence?
Your Honor, the officer's observations, the third-party observations taken together are still not enough to get to the level required for probable cause. The conditions of the vehicle, the dent, and the deflated rear tire are things that could have existed.
I didn't list those as part of what I thought might be probable cause, did I?
That is fair. However, the Kia driver did not actually see the accident.
No.
No one saw the accident.
And we're not talking about whether it's sufficient to prove it beyond a reasonable doubt. But, you know, there are at least indicia that perhaps there was some recklessness involved or under the influence, correct?
At the time that the law enforcement officials searched the SVR data, they were only looking for evidence of reckless driving.
Well, are we limited to that? If we think that there was probable cause to look for evidence of, for example, operating under the influence, can we say that's good enough?
Mr. Drum passed the breathalyzer test, and
he may not have been guilty of operating under the influence. The question is probable cause.
Even if you find that there's probable cause, when determining if an existing exemption to the Fourth Amendment's warrant requirement extends to a new circumstance, here the onboard computer and SPR system, the court has to balance an individual's privacy and the government's.
Well, let's explore that a little. Do you agree that people have a lower privacy expectation in their vehicles?
Yes.
Do you agree that motor vehicles are mobile, so there is an inherent exigency to search them?
Yes.
Do you agree that if probable cause gives you the right to search, you can search any part of the vehicle?
Yes.
So how is downloading information from an embedded computer on the vehicle that has information in it any different from ripping out the seats to see if you can find evidence of a crime or evidence of any crime?
Well, there are a couple of reasons. Digital spaces are not the same as physical spaces. So first, digital data is not visible. Ripping open the seats, you can immediately see what's inside. In order to access this digital data, the Burla IVE device had to be plugged into the car to translate those ones and zeros into intelligible information. Second, there's an unnaturally large storage capacity to these devices. Everything that is saved on it could not fit in a car if it was a physical device. It's almost like Hermione Granger's magic bag that's enchanted. It's infinite, whereas a car is finite.
As you know, the underpinnings of the automobile exception is the fact that the evidence can drive away. That's at the heart of it. And that's true whether there's drugs in the trunk, it's true whether there's something on the person driving, and it's true of the data that exists within the automobile. Is your challenge to the fact that the data was downloaded at the time? Is that the nature of it?
The underlying justifications of the automobile exception don't carry over to the digital data in this case.
But if it's not downloaded, that data can drive away, just like the entire foundation for the automobile exception. Doesn't that overarching policy aspect mean that if it's in the car, it's available for seizure?
Yes, seizure, but not search. Is the
standard different for seizure versus search?
Yes, for being able to, for the probable cause standard, Your Honor?
Yes.
Yes. No.
So you're making a distinction. Your objection is the fact that it was downloaded at the time, right?
Yes, that is a physical trespass as seen in Jones when a GPS device was placed on a car, and that is a violation of the Fourth Amendment.
Okay, what I'm getting is the distinction of, obviously, if there was something, if there's inculpatory evidence in the vehicle at the time, that could be seized. Mm-hmm. So if there is inculpatory evidence, an interesting side point, if there's inculpatory evidence at the scene that's in the form of data, can that be seized at the time?
Your Honor, you're asking if there is data that could implicate a crime, can it be seized?
Well, I put that footnote on the question. That wasn't part of my original question, but go ahead and answer it anyway.
Your Honors, yes, if there is probable cause that the vehicle contains evidence of a crime, yes, it can be seized.
So can I be clear about what you're arguing? Is it the actual downloading that is the violation, or is it viewing the data later that's the violation?
Your Honor, our mainline point would be both are a problem. But
why couldn't the data be downloaded and then, if there is probable cause, now have time for a warrant? I mean, the whole point of the automobile exception is satisfied then. You've captured the data, but you haven't looked at it, and you can then insist that the government get a warrant to look at it.
We would accept a holding that goes that way, Your Honor. But getting a warrant is not a lot of work for the government. It is a very fast and easy process, and
it varies. I mean, let me suggest it does vary where you are, how available, what time of day, et cetera. Sometimes it's quick, sometimes not so much.
That is true. In this case, there's no question that the law enforcement officials should have gotten a warrant, get the stamp of approval from a neutral and detached magistrate that there is the sufficient level of probable cause under the automobile exception for this search.
Is it the fundamental test for, under the Fourth Amendment, your expectation of privacy?
Yes.
So now that there's more and more of an understanding of the kinds of computers and the information they collect in your car, shouldn't we evolve the modern thinking to say everybody knows there's going to be these cameras, and if you really want to disable these things, you can? So isn't there that aspect of modern life that suggests that the motor vehicle exception should apply?
Your Honor, this is a case of first impression for the 14th Circuit. As we have seen in other cases with advancing technology, as seen in Carpenter, we're not supposed to uncritically extend something like the automobile exception to new technology.
Yes, but following up on that, it really is these onboard computers. I mean, one of the underlying purposes and how they evolved was to record data. I mean, you have the black box aspect of it, record data as to speed, location, safety issues, et cetera, that in fact are frequently reported to the manufacturer. I mean, doesn't that undercut any expectation of privacy and what's happening in those onboard computers?
No, Your Honor, because the data stored on these devices is much more. In this case,
it may be more, but one who has it also knows that some of this data is being transmitted.
Your Honor, most people probably don't know that when you connect a cell phone over Bluetooth, it is storing your cell phone data, which, as we saw in Riley, is entitled to heightened privacy protections.
Well, doesn't the fact that this information is being stored on board, but it's also being uploaded, as you were suggesting, back to the manufacturer, vitiate the need to immediately get this information? Because even though the car drives away, the information is stored somewhere else where you can obtain it.
Your Honor, can you please reframe your question?
Well, to the extent that the data is being made available to the manufacturer, which you suggested, that would speak to the point that this information is available through another source, notwithstanding the fact that the motor vehicle is mobile.
Your Honor, in Carpenter, which deals with cell site location, which is uploaded to the manufacturer, you still have to get a warrant before searching that, and that's because it implicates...
And I'm agreeing that to the extent that it's available someplace else, it gives you time to get a warrant as opposed to attempting to seize it at the...
That's called softball.
Hard to identify in the moment, Your Honors.
I'm pitching, but you're not catching.
Does it matter? Should we be looking at the nature of the data that was retrieved in this case? So I understand that the video here at issue was taken in the defendant's garage. Is that correct?
Yes.
What if the video was, instead of the defendant perhaps outside his own car, but on a public street where typically we wouldn't recognize any expectation of privacy? Is that a consideration that we should be taking into account in determining whether this particular data should be suppressed? Or are you arguing for a bright line rule that this type of video evidence should never be accessible?
Your Honor, the best solution is a bright line rule that this data cannot be accessed, period. And that's because on the footage, it shows inside the house, the curtilage of one's home, Mr. Drum's garage, which has a heightened expectation of privacy as seen through Collins. And when the automobile exception and the privacies afforded to the home collide, we know that the protections afforded to the home, which are the strongest Fourth Amendment protections, win out.
But what do we do with the fact that much of this data that can be retrieved is something that we might argue one does not have a reasonable expectation of privacy in? For example, walking down your street, walking around the outside of your car in public, or the data that just shows, how fast you drove, where you drove. I mean, that's something that someone observing the vehicle could also assess. So what do we do with that information?
Your Honors could decide to make a rule that makes that accessible. However, as we've seen in other cases, when there is long-term surveillance, that is much more data that is being recorded than if a law enforcement officer were to tail someone. The vehicle on the car never forgets. It can tell everywhere a person has been, when they're wearing a seatbelt or not, when the car door is open and where. Altogether, that paints a intimate portrait of a person's life, who they associate with, and that where they go to church or synagogue. That sort of information is private, as seen in Jones and Carpenter long-term location tracking data.
Thank you, counsel. And Attorney Inabanza, we're happy to hear your argument this morning as well.
Thank you, Your Honor. Chief Justice, may it please the court. The searches of modern vehicles, onboard computer, and SVR systems fall squarely within the scope of the automobile exception. Case after case, the United States Supreme Court and other court of appeals have extended the automobile exception to every part of a vehicle. Now, this court need not ask itself whether the automobile exception applies to those systems. The answer to that question has long been settled by our highest court's jurisprudence. The more pertinent question is whether or not those systems are somehow precluded from that exception simply because they bear some functional similarities to mobile devices. Your Honors, the government respectfully submits that they are not. And thus we therefore ask that you affirm the lower court's decision to deny Mr. Drum's motion to suppress evidence and hold that the automobile exception applies to the searches of those systems. And we ask that you do so for the following 4 reasons. The first being the automobile exception has been extended to every part of the vehicle. Secondly, the rationale for the automobile exception apply with full force in this case. Thirdly, the government has a substantial interest in effective law enforcement. And lastly, Your Honors, the requirements of the automobile exception were met. Now turning to my first point, but with that, I welcome your questions. Your Honors, law enforcement may search every part and
Well, since you said you welcome our questions.
Yeah.
And the green light coincidentally went on. You said that one of the reasons we should go there is the government's substantial interest in law enforcement and crime detection. But that's not a basis to change or alter or undermine the Fourth Amendment, is it?
No, Your Honor, that is simply...
It may be true, it may be that but that is really not one of the factors for what is permissible under the Fourth Amendment.
No, Your Honor, it is not part of the factors under the Fourth Amendment. It is a policy consideration that is important to take note of, but under the automobile
we're courts.
exception,
Policy is for the legislature.
in most cases, yes, Your Honor. Although the court has, through the judicial powers, may decide decisions based off policy rationales like the automobile exception.
Well, the general policy under the Fourth Amendment is you need to get a search warrant, right? That's the general rule.
But there are exceptions, Your Honor.
Yes, but why, as in this case, what was the problem with getting a search warrant? Why didn't you?
Your Honor, the automobile exception is no broader or no narrower than a search that was conducted with the authorization of a warrant. And because of the exigency in this case, that is...
Well, let's talk about that exigency. So you're talking about it as being part of the automobile exception, except when the search was actually conducted to retrieve this information, the automobile was nowhere to be found in the officer's possession. The automobile was off and getting repaired somewhere. This was a couple of days later that they actually were looking at the digital information. So if they have the information in their possession, at that point, it's completely divorced from the automobile. Why would the automobile exception then permit this search that happened days later? If I follow your argument, it could be weeks later. Months later, car could be wrecked, gone. Who knows what happened to it? It was sold.
Your Honor, under the automobile exception, the United States Supreme Court in Chambers has already stated that there's no separate exigency requirement needed once the requirements of the exception were met. That is, the car is readily mobile and there is sufficient probable cause.
But my point is, you're not searching the car 2 days later. The car wasn't anywhere near where the officers were.
Yes, Your Honor. Under Ross, the United States Supreme Court also stated that you can search both the vehicle and its contents.
Correct.
So in this case, Your Honor, the data, which is deeply embedded in the vehicle, the operation of the vehicle, would be classified as part of the vehicle, and if you would like to go that way, also contents. Now, moving
So
on.
if I have my...
Let me ask you a hypothetical question. Justice Connors refers to these as the dreaded hypothetical questions.
Well, these are well-trained students. They understand
They
what a
understand.
hypothetical is.
But do they understand it as dreadful?
The answer is not, that's not this case.
Which is what lawyers have a tendency to
And
say.
you can't say that. In my hypothetical, the person's driving the car, they have an SVC system, but they also have their cell phone plugged in the car. For that hypothetical situation, does a cell phone get sucked into the automobile exception simply because it's plugged into the charger there?
What if it's plugged in to be used as GPS? I do that every day.
Your Honor, the cell phone being plugged in, some of that data would come under the automobile exception. And when you actually look at the functioning of the vehicle, individuals would plug their phone, and that data is directly pertinent to the functioning of the vehicle. For example, you're driving on the road, and you receive phone calls and text messages via your car. There's GPS location that you need to use. Your Honor, that in and of itself falls squarely with the Supreme Court in Katz saying that what you make publicly, you kind of lose that Fourth Amendment protection. And so individuals that bring their phone and their cell phones in their vehicles have an understanding that this vehicle collects that data.
Well,
How about, I'll add a nuance. The beauty of a hypothetical question is you can change the landscape as you go forward. In this instance, the cell phone is just plugged into the charger. Has nothing to do with the vehicle's electronics. Does that change the calculus?
Not necessarily, Your Honor, because you would need to Bluetooth connect to the vehicle, and so just simply connecting your charger on the vehicle doesn't automatically warrant that the vehicle takes that information.
but it's now a container inside the vehicle. Why can't you search it?
Your Honor, could you please repeat that?
Isn't your phone now a container inside the vehicle? Can you search it under the automobile exception, even if you couldn't search it if it weren't in a vehicle?
Well, if there's probable cause to believe that evidence of reckless driving was in the cell phone, you could be potentially able, law enforcement could be able to search that cell phone.
So your argument is that if I leave my cell phone in my car or my laptop in my car, and law enforcement thinks that there might be evidence of a crime on those devices, it could seize and then search those devices without a warrant simply because they're in the vehicle? Is that the argument you're making?
No, Your Honor. The argument we are making is that where there is probable cause to believe that evidence will be found, and in this case about reckless driving, law enforcement would be able to search those spaces. Moreover, Your Honor,
Including my phone and my laptop, if they had some reason to believe there was evidence of reckless driving on those devices?
based off of that hypothetical, Your Honor, that's probably a scenario that probably wouldn't take place. I think
Well,
the
let's
facts
change
of
the
this
hypothetical a little bit and assume there was probable cause to believe drug trafficking.
Okay.
And you stop the vehicle. I know there wasn't in this case, but let's assume there was. You stop the vehicle, there's a laptop and there's a phone in the car, and you find drugs in the car. Can you also search the phone and the laptop without a warrant?
Your Honor, based under the automobile exception, because that scope of that search is no narrower or broader, and the United States Supreme Court under Ross is essentially stating that it is as though you have been given a warrant, you would be able to search those contents of the vehicle if you have probable cause. Your Honor, probable cause here is the limiting factor, is the check actually, is the protection for the privacy interest.
With my phone in my hand and I'm also videotaping some of the wildlife that's running through, and I just happen to weave over and force another car off the road and then lose control of my car. If that's the basis of the probable cause, you say then you're entitled to get the phone and search it.
Without a warrant.
Without a warrant.
Probable cause really isn't the issue here. We're talking about with or without a warrant.
Your Honor, it would be that determination would be constrained by the standard for the probable cause review. That is the totality of the circumstances. Law enforcement would need to get at the scene, and based off what is available to them, the facts that is available to them.
Okay, plenty of probable cause. That's not the issue. I think
Okay.
we're asking, do you have to pause and get a warrant to do the search, or can you search it without a warrant pursuant to the automobile exception? Keeping in mind, the Supreme Court has said you cannot search a phone as a search incident to arrest without a warrant.
Yes, Your Honor, the search incident to arrest is different from the automobile exception. The automobile exception probable cause analysis is directly pertinent to the places in which the officers want to search. The search to incident arrest exception, in that case, law enforcement just need to arrest you, and then they would have unfettered access into your digital data, which is not the same under the automobile exception. And so, Your Honor,
But the reasoning that the court used in Riley as to why they couldn't search the cell phone incident to the arrest exception is because our cell phones contain all our personal information, our lives. Is the computer that's embedded in the car, does it have similar information and more such information as we go about with these computers that are embedded in our cars?
No, Your Honor. The cell phones, onboard computers, and SVR systems are not cell phones. The court in Riley.
But don't they contain a myriad of digital information, some of which may be very personal, in part because it does, in fact, connect and download from other devices?
There is some functional similarities. However, that in and of itself, Your Honor, because of the fact that the onboard computer system is limited to is a limited space, and even the data that is stored in the onboard computer and SVR system is limited as compared to a cell phone that has infinitely vast amount of data, decades long.
Let's talk about how limited it is. I mean, in this case, the government is using a video of the defendant in his own home, which is typically what we would consider sort of the height of having an expectation of privacy. So I struggle to understand how that's limited data.
Your Honor, if you have a legal right of access into, say, for example, the curtilage of an individual's home, and you were to see something that would be covered under the covered under plain view doctrine. In this case, the automobile exception is the right of access. Moreover, the law enforcement in this case, if you take a look at Joint Appendix A, you'll see that law enforcement were searching video at the time of the incident. And so that they inadvertently saw the footage.
Right, and I understand the plain view argument, but I guess my point is that you've argued that the data contained on these onboard computer systems is limited. It looks to me like the type of data is quite broad, perhaps more akin to a cell phone than typically what we might expect to be in containers in a vehicle. So explain to me how you see the data available here as limited.
Your Honor, the data in the onboard computer systems and SVR systems are limited for the fact that they are directly pertinent to the functioning of a vehicle. So when the SVR system collects that data or collects those images, it is a protective measure against theft for the vehicle. And so that data that is being collected has very little to do with the privacies of someone's life, for example, but more about the functioning of the vehicle.
It's parked in my garage and it's watching me go about as I'm doing other things rather than driving the vehicle, and I've closed the garage door. I am not inviting the world in to see what I'm doing. So why doesn't that violate that?
Well, technically, Your Honor, you are potentially inviting the world into your curtilage if you have an understanding that this vehicle takes footage and how the SVR system works.
You just said something. So do you think that most people know that their vehicles are filming them when they're in their garage?
Well, Your
If they're modern cars.
We probably can assume that. Can I ask you, as your time is winding down here, these issues of search and seizure always involve a balancing between the government's interest in law enforcement and the private party's interest in their privacy. How do you see the balancing of those two valid concerns here, and why would they favor the position you're arguing for?
Your Honor, individuals have a reduced expectation of privacy in their vehicles. And what you knowingly put in public, you can't then now scream Fourth Amendment protection. Now, when you balance that out with the government's interest, that is, there's in situations just as this case, there is not a lot of direct evidence as to what happened. And so law enforcement might not be able to have sufficient, might not be able to gather evidence.
I'm going to suggest again that the fact that the government really wants the information is not a reason to undercut the Fourth Amendment.
Well, yes, Your Honor. However, the automobile exception's exigency, because the data could easily be lost and the evidence could easily be taken away just as quickly as a vehicle. I mean, you could factory reset.
But they downloaded or they accessed the data and let the automobile go away and then didn't access the data and actually search it until like a couple days later, right? You may answer.
Your Honor, the United States Supreme Court in Chambers clearly stated, and as well as United States v. Jones, that you can search the car you could search the vehicle at the police station. You could also search it 3 days later. So the delay in time of
That's
the search.
assuming you actually still have the vehicle.
Yes, Your Honor. Which would be, if you have the data, it's akin to that. Thank you.
Okay, thank you.
Your Honors, I raised 2 points on rebuttal. First, the automobile exception cannot be used as a shortcut to access data otherwise off.
But isn't the problem here that the kind of data that is on the onboard computer really is primarily, I understand it gets other things, but it is primarily related to the operation of the vehicle and is, in fact, is reported for accident data and things like that. And so there really isn't expectation of privacy in that.
No, Your Honor, there is an expectation of privacy in long-term location tracking as seen in Jones and Carpenter. Here, your vehicle has GPS built into it. That is long-term location data that is entitled to Fourth Amendment protections. Additionally, there are high protections, as has been mentioned by Your Honors, afforded to the curtilage of one's homes. In fact, the highest protections afforded under the Fourth Amendment. And therefore, it's important to make sure we're balancing an individual's privacy interests, which are very high here, with the government's interests.
So you're saying here that the person's right to privacy and what they're doing, whether it's legal or illegal, trumps the government's interest in law enforcement?
Yes, absolutely, Your Honor. In this case, the government had the data. It is very difficult to delete data, as you can see on Joint Appendix page 11. And additionally, as seen in a modern example in the disappearance of Savannah Guthrie's mom, people thought that the Nest camera wasn't going to be able to, they weren't going to get the footage off of it. Specialists were able to get that footage off even though she didn't have a subscription that was backing it up. Therefore, Your Honors should reverse the district court's denial of Mr. Drum's motion to suppress evidence and hold that a warrant is required to search a vehicle's digital spaces.
Thank you. Thank you, counsel, for your argument here this morning. This is the point where I usually say we're going to take the matter under advisement, but we're actually not. We don't have to decide this issue. So there you go. I think everybody deserves a round of applause. What do you think? It's customary at this point to see if any of my colleagues have any words of encouragement or otherwise that they wish to give at this point.
Senior to junior or junior to senior?
Oh, well, let's start with the most junior.
Most junior.
We do everything in order of seniority.
I'll be brief. You both did a wonderful job, a really excellent job. I would venture to guess that this will be your most nerve-wracking argument ever, not because it's your first, but because all of your peers and professors are here, and that is a very intimidating audience. So it's only going to get easier from here, and you're starting in a great place. You both did an excellent job, so it was a pleasure to be here with you.
Justice Douglas?
I completely agree. I would also like to add that you were both very impressive. You got some pressing questions. You withstood the barrage very well. You stayed on your feet. You were pretty nimble. You had a command of the facts. You understood the law. Very impressed, indeed. And I just want to say a word about the briefs, too. I thought they were very excellent. I don't know who authored them, but they were very well done. And I also commend whoever devised this problem, so to speak, this issue. It's really a great one because it's well balanced, it's undecided, so a lot of latitude for the students and a lot of latitude for the court. So well done, everyone.
I echo the sentiments expressed by my colleagues, and I'm just happy that you've had the opportunity to be exposed to the dreaded hypothetical.
Yes, I assume you both were very poised, very good conduct, and I assume that's because you were mooted 8,000 times before this. And when I was listening, I was thinking about, so what's the hardest thing when you are just starting off with doing oral arguments? And it's what came up a little today. You have to know, what am I going to concede, and what is a softball question? And these issues, they resolve themselves over time. So since you're so good to start, argue a lot. The more you practice, the better you're going to be, and you're already starting at a very high level.
Outstanding job, just absolutely top-notch. I mean, it's at the top tier of lawyers with years and years of experience. You did a great job, and that speaks well of your own abilities, also your faculty who brought you here, and also your colleagues who had the wisdom to matriculate at this super institution. Faculty is an unlimited resource that you need to tap into, and you obviously have done that. I agreed with the points made already. It's always a powerful thing to appear that you're conceding something. So if you have a point you can kind of give away, it makes you sound really reasonable coming through the gates. And as far as the dreaded hypothetical went, congratulations for not saying once, well, that's not this case. Because when we hear that, that's sort of a signal to us like, ooh, I don't really want to answer that question, so I'm going to push back on it. So, but you jumped right into it and went with the flow, and that's the way to handle a hypothetical. So congratulations to you all. Just a terrific day for everybody present here in this courtroom.
What they said. The dreaded hypothetical has become a little bit of our in-joke for the last number of months because it did happen on several arguments in a row where it was always Justice Connors saying, well, let me ask you a hypothetical. And then she would ask the hypothetical and they'd go, well, that's not this case. And it was like, right. It was a hypothetical. So that's why that has turned into a bit of an in-joke for all of us. Well done. I mean, I can remember that at the time remembering, like, how am I going to remember all the facts and everything else? Of course, in real life, once it's your case and you lived with it for, ever, you don't have any trouble remembering the facts. In fact, you know far more facts than you could ever possibly tell us. And one of the things about oral argument, and I think sometimes people get frustrated because they sometimes get cut off and don't get out what they wanted to get out, and that's okay, because it's a very limited amount of time, and it should be a conversation with us, and you get to find out. You should welcome, and I think you did, hearing what it is we want to hear about. These are the pain points that we're seeing, right? We're testing because they're the pain points we see in the argument. Sometimes I think it feels frustrating, but it really is a conversation. You can welcome that conversation, and you all did a really wonderful job of doing it, so thank you. It's always a pleasure. So with that, we'll let all of your friends, family, and acquaintances and hangers-on congratulate you. I was told there may be a request for photos. I don't know. I have no idea, so we can do that if you'd like and come around or have students come up. It's up to you. Why don't you confer with our clerk and tell us what you would like. But thank you and congratulations.